Good morning, everyone. We'll go ahead and get started. Well, welcome and thank you, everyone, for coming. As you know, we're here today to discuss how Harvard has shaped the law. Noticeably, the title of today's event is not "Has Harvard Shaped the Law?" While that may have been a lot less presumptuous, it would have made for a pretty short panel. Of course, the answer is yes, and we're very fortunate to be affiliated with a historic institution that has played such a central role in crafting the law, from how it's taught to how it's practiced. And today's panelists bring a phenomenal amount of wealth of expertise to a wide array of disciplines within the law. And the Harvard Law Review recently published its Bicentennial issue featuring essays by our panelists exploring the ways in which Harvard Law School shaped the evolution of their discipline, and in some instances, how their discipline has shaped HLS. So today we're joined by, of course, Dean John Manning. In his essay on statutory interpretation, he studies the work of a discordant group of Harvard law theorists who, despite deep differences, found common ground in the shared project of rejecting the idea of legislative intent. We're also joined by Professor Kimberlé Crenshaw, who in her essay narrates the Harvard origins of the critical race theory as a movement and as an approach to legal education. And in her essay on legal education, Professor Jeannie Suk Gersen examines the Socratic method pioneered at Harvard Law School and its possibilities for equipping students to be thoughtful lawyers and members of society. And weaving together strands from Holmes to Thayer to Brandeis, Professor Vicki Jackson comments on how the role of courts in our system of government have played a role in pushing constitutional law to constitutional justice. Professor Adrian Vermeule engages with multiple generations of Harvard scholars, including Justice Kagan, who have probed the legitimacy of the administrative state. And finally, Professor Frederick Schauer, in his writing on American jurisprudence, notes that Harvard Law School has been influential on widening the scope of sources that constitute law. I think we're in for a real treat. And this panel would not have been possible without the guidance from Dean Minow, who wrote the fabulous introduction to these collection of essays, as well as the advisement and encouragement of Dean Manning and Professor Lazarus. I'm also so grateful for the editors of the Harvard Law Review for their tireless and exceptional work. So we'll begin with each professor giving the 200-year summary of their field of expertise in about 5 minutes. And then we'll move into a moderated discussion before opening it up for Q&A. And we'll start with Dean Manning.
Thank you very much, Imelme. And it's great to be here. Let me just say it's great working with you. Imelme was my student in legislation and regulation, and fantastic that you're president of the Law Review, and working with the Law Review on this and every other piece of work I've done with them has been a tremendous, tremendous experience. And working with the editors as they conceived of this issue and executed it and brought it to fruition was just a model of professionalism on their part. And so it's great to be here, and I'm delighted to be here with this very, very distinguished panel. So I write about, or maybe that was the right tense. I wrote about statutory interpretation, and when I went to law school, and I started 35 years ago this fall, we didn't talk much about statutory interpretation. What was assumed was that you looked for the legislature's intent. And there's a certain common sense to that, right? When we think about what we mean in conversation, we care a lot about what the people we're talking to intended by what they said. And so you've said, oh, I didn't intend that, or I wonder what he or she intended when they said that. And it extends to the idea of sometimes people say things they don't intend. So if a friend says to me, sends a note that says, let's meet for lunch at 1 a.m., I'm pretty sure that there's a typo there, that they intended it to be 1 p.m. And I'll show up at 1 p.m., right? Even if I haven't contacted that person. And the sort of the idea of statutory interpretation when I went to law school and when some other people in this room probably went to law school was that that's what judges were trying to do. They were trying to figure out what Congress intended by the words that they used. And that meant go and look at what the drafters said, so look at some legislative history and try to figure out what the principal sponsors or the committees that drafted the legislation meant, and that was intentionalism. It was very, very widely accepted, went largely unchallenged for many, many years, and was taken for granted in the law schools and in the profession. And so the big challenge to that was modern textualism. Modern textualism is associated most closely with a graduate of this law school, Justice Scalia, who made a broad-ranging critique. He and some other judges made broad-ranging critiques of the idea of looking for legislative intent. And one of the central tenets of what they said was that legislatures on any hard question simply don't have an intent. So if you think about the proposition that underlies legislative intent, it presupposes that you can discern on a hard question what 536 people spread across 3 institutions, I'm counting the president in here, intended about something that they didn't express clearly. And you add to that the fact that the process of legislation is so complex, has so many veto gates, there's so many ways for legislation to die, it's very hard to reconstruct what legislation was meant to do. And so textualists say, just read the words. All right, so that's sort of the baseline here. What I discovered when I went and I read about a bunch of Harvard theorists is that this idea about intent skepticism, not textualism, but intent skepticism, cuts really deep, and it cuts across all sorts of different theories, including some that are very, very inconsistent, incompatible with the theory of textualism that's most closely associated with it. So I found that Harvard's legal realists, progressives, New Dealers, legal process purposivists, along with its textualists, all were intent skeptics. And I'm not saying that everybody who's ever been associated with the Harvard Law School is an intent skeptic. There is ample evidence to the contrary. But what I am saying is that there's a deep tradition and a very impressive lineup of people going way back who were intent skeptics also. So I can't mention every one. The article runs 36 pages, and I'm only going to mention 3 quick examples just to show the range of views that are associated with intent skepticism. So Roscoe Pound, who was a professor and a former dean of this law school, was one of the leaders of the progressive movement, and he was associated with a movement called sociological jurisprudence, the idea that judges should ground their interpretive decisions in social realities and the imperatives of justice, not in the formalities of statutory text or common law. And yet, this view, which is very different from modern textualism, was grounded on the idea that, and I'm quoting here, the legislature has, quote, no actual intent, and that, quote, the difficulties of so-called interpretation arise only when the legislature has had no meaning at all. So here's a second example, also a professor and a former dean, James Landis. He was one of the great intellectual architects of the New Deal. And what his main argument was that American judges inherited equitable powers from English judges, and therefore they could readjust a statute to make it more coherent and fair, even if it didn't match up with the text. Again, very different from what modern intent skeptics argue. He also said that most of the time, quote, the meaning of the legislature is not discoverable, and that he said that courts only invoke legislative intent to elide, quote, their role as actual lawgivers. All right, that's example 2. Third, and this was the one that surprised me the most, is Professors Hart and Sachs. For those of you who have taken legislation and regulation, I hope you are, and many people in the room probably took the legal process course. You're familiar with the legal process school. It was the dominant school of interpretive thought for 2 generations, 3 generations after World War II. It's a very sort of constructivist theory of interpretation, and what it says is laws should be interpreted purposefully, and we should presume that legislators are reasonable persons pursuing reasonable purposes reasonably. It's often, this was the dominant approach on the court for decades, and it's often associated with the idea that you can reconstruct what Congress wanted to achieve, their intent. But Hart and Sachs said the following: in most cases, quote, the overwhelming probability is that the legislature gave no particular thought to the matter at all and had no intent concerning it. So all of these theories, very, very different theories of interpretation, all rest on the idea that you can't reconstruct what Congress was actually deciding. And I think that this, if you want to call it the Harvard School of Statutory Interpretation, to me has two virtues. One is it seems right, right? It seems right to think that if you've got a hard interpretive question, then 536 actors spread across 3 institutions in a very, very complex, opaque, path-dependent process have not decided the question at issue. So it seems right. The second thing is, it seems to me to be a more forthright way of thinking about the problem of interpretation. All of these theorists grappled with very hard questions about interpretation. And the questions they grappled with were, in our constitutional system, how is the power of lawmaking allocated? When does Congress make law? And when does it fall to legislatures and agencies to make law when Congress hasn't decided? And that seems to me to be a more accurate and I do think forthright way about thinking of the problem of statutory interpretation. It was really fun to write this essay. I'm very happy and grateful to have been invited to do it, and I have now subsided.
So I'm also delighted to be part of this special issue and part of this conversation. I'm going to shift the question just a little bit, and maybe already said that I was going to more or less talk about the influence of things that happen here at Harvard on the way we think about and engage law and its relationship to race. I'm going to start with just a couple of snapshots of some things that I've noticed over the last couple months. Just 2 days ago, I was at Brandeis meeting with several graduate students. These graduate students had created a course on critical race theory. These were not graduate students in a law school. These were graduate students who were studying international relations, sociology, political science. Last month, I was in Germany for the inaugural conference around a center called the Center for Intersectional Advocacy and Policy in Europe. The 2 months before that, there was a critical race theory conference in Germany, and the year before that, there was a similar conference in the UK. The year before that, I heard about the creation of a Center for Intersectionality Studies in Canada. What do all of these things have to do with Harvard Law School? All of these have been outgrowth of a particular moment in Harvard Law School history in which competing ideas about how to think about race, how to think about racial power, and its relationship to law came to a head. Out of that coming to a head came the movement of critical race theory, and out of critical race theory came intersectionality. So I've told you more or less sort of the end of the story. Now I want to roll it back and tell you a little bit of the conditions of possibility and one of the stories that I talk about in my article. So one of the stories that I elevate is the moment when legal defense, NAACP civil rights lawyer wrote a piece called 9 Men in Black Who Think White. It was basically an assessment, a critique of the Supreme Court's performance in racial justice issues, in particular, the celebration of Brown 1, which established the principle of non-segregation in public schools to Brown 2, which established the fact that it would take at least 10 years before the Supreme Court would revisit it again in a significant way to force significant integration. So his point of departure was that there was a celebration of the law, a celebration of the idea of the Supreme Court as being the font of moral as well as constitutional judgment around racial equity, and at the same time, the reality that there were many opportunities that were apparently being missed in the aftermath of Brown. For writing this article, he was summarily fired by the NAACP without any process, without any review, without any conversation. The counsel general, who was who went on to become Judge Robert Carter, also resigned. The entire legal staff of the NAACP resigned at this moment. This is not a story that's well known to students of civil rights law, students of race history, students of constitutional law, students of social justice activism. I wanted to bring that story forward to say that this story is simply one of many moments where there were conflicts between different ways of thinking about race and law. One of the sites of that conflict was Harvard Law School. I came to Harvard Law School in the early 80s during a time that Derek Bell had recently left. We, as students coming out of the civil rights movement, were here to learn how to extend the reach of the civil rights movement, to learn the skills, the tools about how to go about civil rights advocacy, and we thought that Derek Bell's presence here was one of the main attractions. When the law school expressed no commitment to rehiring someone to teach his courses or to teach his actual courses, it began a series of protests and interactions and actions that heightened the tension between these two ways of thinking about race and law. One was the traditional way, which was law was basically a referee about and around racial conflict. It was a way of managing racial groups. It was a way of determining when certain outcomes could be traced to a legitimate, illegitimate biased decision-making, and when certain outcomes were just that natural outcomes of the fact that people are different and races are different. That was a traditional way. It was a way of thinking that had bona fides. It was a way of thinking that shaped the decision of the NAACP to fire Louis Steele, because Louis Steele was undermining that particular vantage point. Another way of thinking about race and law, one that was in many ways represented by Derek Bell, but then heightened by the interaction between this way of thinking and critical legal studies, was that law wasn't just a referee of race. It wasn't just a post hoc institution that determined when race could or could not be a basis for distributing things like jobs or burdens like incarceration, but law helped to actually constitute the things that it claimed to simply manage. That was an idea that thought more about law as a system of power. It thought about race as power relations, and law played a significant role in rationalizing the current distribution of who gets what in society and naturalizing that. These ideas I say now as though they are always there, they were always relevant, but they were not always there. In fact, we were prompted by the failure to actually include such courses to actually come up with our own course as a way of exploring, understanding, and developing an approach that I've just mentioned. That political moment and that institutional moment was all the arena out of which critical race theory came out. The short story is simply the convergence of students who were both interested in a race project and interested in a critical way of thinking about law, actually came together in the struggles here at Harvard Law School around the alternative course, in the struggles here at Harvard Law School about how we think about race and law. So my piece is basically a way of going back to that history, telling the story in terms of we became critical race theorists because we fell through the cracks of traditional liberal approaches to race and traditional critical approaches that did not yet have an approach to race. So critical race theory is not so much a thing with a lot of stuff in it, but a series of interactions. And these interactions help constitute our understanding about how race and power occupy institutions like Harvard, and then by a greater extension, how race and power might be thought about across the social terrain.
Thank you. I wrote about something that is probably near and dear to all of your hearts, the Socratic method. So, as many of you may know, Harvard Law School is the birthplace of the Socratic method of teaching. It began as the case method, or the Langdell method, and it was named for its first practitioner at Harvard, Christopher Columbus Langdell. And so when he joined the faculty in 1870, after having been a practicing lawyer, he looked around and thought, the way they're teaching law is boring, it's not engaging, it doesn't make students think, and I want to do it differently. And so the old way, prior to Langdell's intervention, was that professors would stand at the head of the room, kind of like we're doing right now, and just talk, maybe even read aloud from treatises, and just summarize what was in the textbook. And the students would listen, and they would take notes, and then maybe once in a while they might ask a clarifying question, and then receive an authoritative answer, and that would be the way that the class went. And so in 1870, when Langdell decided that this wasn't the way he wanted to do it, he got a lot of pushback from his colleagues, because what he was trying to do, they thought, was really radical. It was very innovative. And what he proposed to do is, first of all, don't read from textbooks and summaries, but rather use the primary material, the cases themselves. And so give the students the cases to read, and then have them engage in interpretations of those cases by being asked questions, and then asking the students to reason about those cases, and then maybe putting them into discussion with each other. And maybe disagreements would come out, and then also he assigned dissents. So because it wasn't just about summarizing the state of the law, what the law was, but about reasoning and different reasons for coming to different conclusions. And that was the method that he innovated. He started using it. Lots of other professors at the school thought, this is never going to work, because we have so much material that we need to cover. And if we start asking them questions about individual cases, that's just going to take forever, and we're not going to get all the coverage that we need. Well, the other thing that was disturbing was this disruption of classroom hierarchy. If you have the professor at the head of the room just telling the students what's what, that was one way of ordering hierarchy. But here, his idea anyway, was that students should be at the center of the classroom, and their thinking and reasoning process should be really what everyone was focused on. And so a lot of students who experienced Langdell's new method, they didn't like it because they weren't used to it. They thought, I came to class to hear a wise professor. Mm-hmm. And instead, I'm listening to Mr. Jones and Mr. Fessenden and Mr. Smith, and why that's a waste of my time. And so they really revolted. And in fact, in his first year, students just stopped coming, and only a handful of students would show up to class. And there were even incidents where people threw objects, like there were cushions that they would sit on in the classrooms, and they would throw the cushions to express their consternation about what was going on. But what I take from it is this focus on students and their minds as learners and thinkers, not on the professors and the professor as the keeper of knowledge and the person imparting knowledge. Okay, so that was the new innovation of 1870. So now let's fast forward at Harvard Law School to maybe like 100 years. So the next figure that I'm going to focus on is Duncan Kennedy, who I believe is here in this room. Yes. So Duncan Kennedy, so in fact, it started a little bit before he was at Harvard Law School, when he was a student at Yale Law School. And he wrote this essay while he was a student there called How the Law School Fails. And it was a very acid attack on the Socratic method as it was practiced in legal education at that time. He called it an assault, that the way it is practiced is an assault by the professors on the students, that they were inflicting emotional harm on their students, that they were being sadistic. And then a little later on, he published a famous essay called Legal Education and the Reproduction of Hierarchy, in which he took that further and said that the Socratic method is a way of enacting that hierarchy, so that the professor asking the question is kind of encouraging the student to submit and inducing them to submit to authority. These are two very different pictures of what's going on. One is Langdale's vision: the students are going to become more independent, more autonomous, and they're going to have more self-confidence, and they're going to have a capacity to criticize and to say, well, maybe this isn't the way we should do it. In Duncan Kennedy's vision, what's actually happening on the ground in law school classrooms is that it's a mode of interaction that is actually not cultivating that independence and autonomy, and in fact doing the opposite. So over the past decades, other people, of course, have observed the connection between the legal professional style, the pedagogical techniques of the classroom, and then what happens to the students and how they feel. And Lonnie Grenier is another figure who talked about the way that the legal professional style is white, male, and middle class, and that comes out in the way that it's practiced in the classroom in the Socratic method. And lots of people, lots of students have, in fact, said, and they've even told me, that encountering the Socratic method for the first time as one else impacted their sense of well-being and equality, and some people have talked about a disproportionately negative impact on women and minorities. So that's another moment and a critique of the Socratic method that I'm very concerned about. So in recent years, we have seen also this turn toward thinking about the connection between the Socratic method and the harm to students as a form of trauma, in which people think that, for example, when you call on students, that it's kind of like subjecting them to a kind of trauma. And in fact, there's a student group here at Harvard called Harvard Assault Law Student Training that warns on their website that professors should try not to use the Socratic method because it can invoke a fight or flight reaction, causing people to shut down and freeze and dissociate, and as if they're being attacked. And I think that there's this comparison of an assault, an attack, aggression. It's as if the use of the Socratic method is being analogized to a kind of assault, and especially a gendered assault, with the attention to the way that the Socratic method has been less comfortable empirically, just when you talk to women versus men, or people of color versus white students. So I think that I lay all that out just to say that the Socratic method has survived a great deal of legal developments at Harvard and elsewhere over a very long period of time. And it is, the paper that I wrote is about the Socratic method, but it's getting at something a little larger than that, which is how to retain the possibility of open discussion, of debate, of disagreement, and yes, of confrontation of different ideas among people who really may see things differently in a classroom and in a university that's increasingly diverse, maybe even divided, and also right now at this moment in time on campuses where we are having these very intense debates about what it means to be inclusive and what it means to have a safe space and what it means to actually have open debate. I think this is a time when the classroom is increasingly perceived as a potential site of trauma, and it's been common to hear references to a lot of things that people may dislike or feel uncomfortable about as if they were a trauma. And I have to say that I routinely now hear from colleagues at this school, at other schools, who say they are limiting or refraining from teaching certain subjects because they're just too hot to handle in the law school classroom, or at the very least, they won't use the Socratic method for those subjects like, for example, race or gender or sexual violence or sexual harassment, they're not going to employ the method, or they're just not going to teach it at all because of the fear of subjecting students to distress. I happen to use the method. I happen to think that it's part of the solution to gender, race, and class disparities in law school performance and comfort. I can say a little bit more about that in the Q&A because I don't want to go beyond my time. But I believe that the classroom should be a space for confrontation, for problems that feel urgently alive and relevant, and for reasoned argument about politically and morally contested matters. And the harder that it may be to have reasoned dialogue about matters of importance in our society, the more important it is for professors to practice doing so with their students. I don't think the Socratic method is the only way to do it, but it is a way that was developed here at Harvard that also was used to great effect by Duncan Kennedy throughout his career and has survived many, many different iterations of legal theory, such as legal realism, legal process, the critical legal studies movement. And I hope that at the 300th anniversary of the school, we'll still be grappling with the Socratic method and its effects. Thank you.
Thank you. So these prior presentations have been so interesting. I kind of want to engage with them, but I'm supposed to talk to you about something else. I'm very happy to be here. I want to thank the Law School, the Law Review for organizing it. I want to thank both last year's board of the Law Review and this year's board because all of these two groups of students worked incredibly hard on the issue. What I wrote about were three Harvard Law School alumni, James Bradley Thayer, Oliver Wendell Holmes Sr., and Louis D. Jr., there we go, and Louis D. Brandeis, all of whom have had outsized impacts on judicial review, how it is conducted and conceived. None of these were originalists. All supported deference to legislatures, albeit for different reasons. Thayer, who was a professor here, supported deference to Congress for many reasons. First, he argued, there may be more than one reasonable interpretation of a constitutional provision. Moreover, he argued, too active a form of judicial review might lead members of legislatures to take their own responsibilities less seriously. Moreover, too aggressive a form of judicial review might produce legislative backlashes that would undermine judicial independence. He more strongly favored deference to Congress, however, than to state legislatures. As I mentioned, he was not an originalist. He urged courts engaged in judicial review to combine, and I quote, a lawyer's rigor with a statesman's breadth of vision. Justice Holmes also favored deference, especially on what liberty was protected by the Due Process Clause. He famously argued in his Lochner dissent that the 14th Amendment did not enact Mr. Herbert Spencer's social statics. Holmes's writings reflected a degree of majoritarianism born of his jurisprudential view that laws essentially reflected the dominant power in society. Not only did he emphasize the need to distinguish the study of law from moral considerations in his famous essay called The Path of the Law, which was in the Harvard Law Review in 1897, but in his later years, he seemed almost exasperated with those who sought to bring law closer to conceptions of morality or justice. I'll quote from a letter he wrote in 1929. I hate justice, he said in this letter. I know that if a man begins to talk about that, he is shirking thinking in legal terms. Justice Brandeis favored deference to legislatures, especially when they were acting to respond to new economic challenges. Unlike Holmes's deference, Brandeis's deference was designed to advance his understandings of social justice. He sought, through improved understandings of the facts, to bring what he called legal justice closer to what he called social justice. To achieve this goal, Brandeis, who was one of our first public interest lawyers, sought to bring, although also a very successful commercial lawyer, he sought to bring to the attention of legislatures and to the attention of courts the social facts about the world he was living in through the Brandeis briefs that he popularized. And these presented the kinds of social facts on which legislatures could have relied to support their legislation, and he presented them in an effort to persuade courts to uphold laws that courts at the time were experiencing as novel and weren't quite sure what to do with. Now, the influences of these three jurists endure in U.S. constitutional law. They endure in at least rhetorical commitments to judicial deference to legislatures and in a certain Holmesian value skepticism. Let me illustrate with a brief anecdote. The first time I taught federal courts here, which would have been in around 2012, I used a handout, a hypothetical, at the end of our study of the very complex law that had developed around habeas corpus for state court convicted prisoners. Very, very complicated. And the handout said you're a legislative assistant in the office of the senator who runs the Judiciary Committee. How would you reform it? Would you abolish habeas, or would you get rid of various judicial doctrines? And the questions went across a spectrum of how one might respond. And I had used this in teaching at a prior school I had taught at for many, many years, and students always wanted to talk. I put the problem out in my federal courts class, and no one wanted to talk. It was one of those awkward moments where there's silence, and I decided not to use the Socratic method at that point, but to try and elicit volunteers, and after a couple of minutes of trying my best to elicit, I gave up. So a couple of weeks later, I was taking a dozen students or so from that class out to lunch, and halfway in, I said, I had a pedagogical failure in class a couple of weeks ago. Remember when I tried to ask people about how you would proceed if you were in the legislature? And they said, yes, they remembered. And I said, well, could you explain to me what was going on there? I was really confused. Long silence. And finally, one of the students said, well, Professor, it sounded like you were asking us to talk about what would be fair or just. And I said, well, yeah, I was. What's the problem? And the student said, well, Justice Holmes. I was really startled by this. That's an illustration of the continued influence of what some see as the justice's value skepticism. Now, in the paper, I argue that these two features, deference to legislatures and value skepticism, help explain why proportionality review, an approach to constitutional rights adjudication widely used in other constitutional democracies, has not been adopted here. What's proportionality review? It's a structured doctrine designed to test the constitutionality of government action claimed to intrude on a realm protected by rights. It does so by asking a sequenced set of questions. Is the measure directed towards a legitimate goal? Is it rationally directed towards that goal? Are the means chosen minimally impairing of rights? And are the values served by the legislation of enough importance to justify whatever intrusion on the realm of rights exists? The emphasis on deference to legislatures by these influential American jurists, as well as Holmes's skepticism that constitutional values can be deduced apart from what majorities want, and this is outside of the free speech and takings area where he had different views, have been very influential, I think, although Justice Breyer has argued that proportionality review might be an appropriate approach for a range of constitutional questions. And one thing I and other scholars have argued is that proportionality review actually can be conducted with deference to the legislature as primary decision maker, and that it offers some benefits in terms of increasing the likely judicial candor of reasoning, the transparency of reasoning, and offers the possibility of bringing constitutional law closer to conceptions of justice. Now, proportionality review and many other constitutional approaches rest in part on judicial evaluation of the facts the legislature could reasonably have found. The Supreme Court in recent decades has tended to focus much more on its law-declaring function, which is surely of great importance. But I urge more appreciation of the importance of having relatively objective evaluations of fact-finding in constitutional challenges to government action. Article 3 courts bring independence and procedurally regular and adversarial methods of the judicial process to decision-making that can be very helpful in evaluating whether the facts on which legislation is based exist within some range of reasonableness or plausibility. We live in an age of truthiness, a word coined by Stephen Colbert in around 2005, an age of fake news, of legislative polarization, and, as Senator John McCain recently complained, a decline of regular order, the existence of what some call kabuki theater in legislative hearings, to say nothing of the relatively new conception of alternative facts. In this period, courts are, among the major institutions of government, perhaps most likely to provide publicly transparent and impartial public-interested decision-making about facts relevant to the constitutionality of laws, whether under proportionality review or other doctrines. So deference may be appropriate, as Thayer, Holmes, and Brandeis in different ways urged, but I suggest it should be deployed in ways responsive to the facts about different governmental decision-making processes. Brandeis, in particular, urged deference because he thought generally legislatures were seeking to advance social justice in ways responsive to developing social facts. I think Brandeis might well have been alert to the new facts surrounding the legislative process. His biographer, Philippa Strum, has written, although Brandeis did not address the problem directly, he presumably would have followed his own logic and said that if the legislature failed to amass factual data before enacting a statute and its lawyers could not themselves demonstrate its social rationality, the law should be struck down. Where other branches do not engage in anything that could be fairly characterized as an objective consideration of social facts, courts may need to be less deferential in order to help keep our constitutional system in balance. Thank you.
Do you want to go alphabetically or in order of seating?
Yeah, seating's good.
Okay.
You're on.
Thank you. Thank you for having me. I want to thank the Law Review and the Dean for convening this. Imelme gave me an assignment, which was to speak for less than 5 minutes about how Harvard has shaped administrative law, and having an extraordinarily literal mind, that's what I propose to do. So to invoke John's example, I will meet you for lunch at 1 a.m., so please be there. Okay. And an interesting question, if anyone wants to do a student note on this, you could correlate people's views about textualism with their literalism in their personal lives. I think that would be an interesting question. Okay. So there's a problem about the Harvard tradition of administrative law, and the problem is an embarrassment of riches. The tradition's just too rich, and the current bench is too deep. And I think that's because Harvard's always been, in a way, more directly involved with government than a number of our putative peer schools. So just a few names of famous Harvard administrative lawyers, in no real order, but Roscoe Pound, dean and architect in part of the APA, or of one sort of take on the APA. I'll get to that in a second. Felix Frankfurter, Supreme Court Justice and faculty member. James Landis, chair of the SEC, dean. Louis Jaffe, professor and one of the great legal theorists of the 20th century. Clark Baez, Antonin Scalia, Supreme Court Justice. Stephen Breyer, Supreme Court Justice. Elena Kagan, Supreme Court Justice. All of these are central figures in American administrative law. among current faculty, it's almost absurd. Jody Freeman, Jake Gersen, John Manning, Todd Rakoff, Daphne Renan, Matt Stevenson, Cass Sunstein, and I could go on. It's quite remarkable, our administrative law richness here. The way of breaking down this richness maybe is to think about Harvard's influence both historically and conceptually. So let me try those two in turn. Historically, we might distinguish some very broad eras of administrative law. This is almost cartoonishly oversimplified, but in the interest of time, so the New Deal era, the kind of new settlement of the Administrative Procedure Act in 1946, the legal process era, the problems of the Great Society in the 60s and 70s, the bipartisan growth of presidential administration and technocratic managerialism after about 1980 and continuing until today, and most recently what we might call the legalist and originalist critique of the constitutional underpinnings of the administrative state. In all these eras, Harvard lawyers have been leaders in one way or another. So I mentioned Frankfurter and Landis, both intellectual architects of the New Deal, as John said. I mentioned that Roscoe Pound, on behalf of the ABA, was a kind of ringleader of the conservative bar's counterattack, if you like, on the New Deal, resulting in a kind of peace treaty that is the Administrative Procedure Act. I think it's best seen as a kind of peace treaty between different social forces struggling over the shape and scope of the administrative state. Jaffe wrote a treatise on judicial review of administrative action that defined the field for a whole generation, for the legal process generation. This was the sort of a quasi-official view of the administrative state. Coming into more into our own era, Steve Breyer and Cass Sunstein have been central in the effort to rationalize administrative governance, especially through cost-benefit analysis and through executive branch institutions. In one of Breyer's early books, he called for the creation of a office within the federal government that would essentially use cost-benefit analysis in a synoptic way to rationalize administrative programs across a range of federal bureaucracies. And OIRA, the Office of Information Regulatory Affairs, has come to be something like that, starting with Ronald Reagan's cost-benefit executive orders in the early 80s. Moving into the Clinton administration, the George W. Bush administration, the Obama administration, a growing theme is presidential administration, and where to look for understanding of this. Well, Elena Kagan's article on presidential administration, published in the Law Review in 2001, is the master text for this, and it has shaped our understanding of this phenomenon ever since. And last but not least, I do want to mention John's work, because his work bridging constitutional and administrative law has in important ways laid the foundation for some very central current controversies. So one of the main controversies in administrative law today is the role of judicial deference to agencies with respect to both statutory interpretation and agency interpretation of their own regulations. And a lot of this goes back to John's work about the constitutional underpinnings and limits of deference. So historically, Harvard people have been leaders at every stage. Let me also offer, however, a conceptual lens as well. I have to be grandiose for a moment and say that the administrative state has always been a terrain for a kind of cyclical, if you like, struggle among competing principles of legitimacy. These are competing principles that try to make sense of the administrative state given our 18th century Constitution, which says almost nothing about the vast bureaucracy that governs us today. So these principles appear, reappear, go in and out of fashion. It's somewhat akin to the eternal struggle among East Asia, Eurasia, and Oceania in 1984. And we might call them democratic accountability, technocratic rationality, and legal validity. So these are the principles I discuss in my essay for the law review. And here, too, Harvard figures have been central in each camp. So Elena's article on presidential administration emphasizes democratic accountability. Jody Freeman's work has said important things about democratic accountability, in particular with respect to the problem one sees over and over again in the administrative state nowadays, which is how to manage administrative problems under statutes decades old that can no longer realistically be updated because of the essentially breaking national lawmaking process. Technocratic rationality, I've talked about. This is Breyer and Sunstein and others. Legal validity, I want to compare and contrast very briefly Roscoe Pound and John's work. These have different emphases. So Roscoe Pound's focus was on common law legalism in an attempt to retrench, as against the administrative state, baselines derived from the common law. John's emphasis is very different. It's on a written textualist constitutionalism and its structural implications for the administrative state, but there is a shared legalist orientation across these two Harvard law deans, I believe. So both historically and conceptually, administrative law has fundamentally been shaped by Harvard, and I think that's true of no other school, and I want to conclude with just a thought experiment. Imagine that one or another of the leading American law schools had simply never existed. Which one's absence would have the greatest effect on administrative law? So I can certainly imagine administrative law without Stanford. Yeah, even more easily I can imagine it without Yale, although my normative views may be infecting that part of the thought experiment. I think the loss of Chicago or Columbia would be more serious. That is, maybe particularly without Columbia, administrative law would be missing a limb or something, but it would still recognizably exist. I just think it's impossible to imagine administrative law without Harvard. In some sense, there wouldn't be a field to talk about because of the role, especially of the early architects, both pro and con the administrative state, Frankfurter, Landis on the one hand, and Pound on the other, in shaping what we now think of as administrative law. So thank you.
So my somewhat daunting assignment has been to talk about 200 years of jurisprudence, 200 years of legal theory, with a focus on the Harvard Law School, and I do that in this issue in an article entitled Law's Boundaries. I should mention that it is good to be back. I spent many years here, and I'm delighted to be back. So in 1906, at a memorial service for the often mocked Christopher Columbus Langdell, Joseph Beale, himself also often mocked these days, observed that Langdell's students complained not only about the method, as Jeannie talked about, but also that what Langdell was teaching was not law. Huh? How could anybody possibly think that English and American cases on contracts and suretyship and the like were not law? And the answer is that prior to Langdell, the prevailing view was that law consisted of enduring principles set forth in legal treatises. The cases were mere illustrations, mere examples. And so when Langdell insisted that cases were law, that they were the primary materials of law, That was, in fact, a radical departure. He not only startled and annoyed his students by that, but he expanded the very idea of what counts as law. That cases were themselves law, they counted as law, was itself an expansion of what was understood to be law itself. The point of the anecdote is to suggest not only that many of the most enduring jurisprudential debates of the last 200 years have been about what counts as law, about the law-non-law boundary, and indeed about whether there even is a law-non-law boundary, but also that many of these debates have taken place literally or figuratively at the Harvard Law School. Thus, even post-Langdell, we have Oliver Wendell Holmes insisting that the life of the law was empirical experience and not syllogistic or even inductive logic. And Holmes also suggesting that knowledge of statistics, which for Holmes meant the broad area of empirical inquiry and not statistics in just a narrow sense, knowledge of statistics was the key to the future mastery of law and not just knowledge of cases and formal legal doctrine. In that sense, he challenged Langdell not only about logic in the narrow sense, but challenged Langdell in terms of just what counts as law. Where do law's boundaries lie? Then we have Roscoe Pound, more of a legal realist than his well-known debates with capital R realists might suggest, seeking to expand the law to encompass a huge swath of sociological, psychological, political, economic, and other empirical data. The important contribution of Pound was not only that these were also fields that people trained in law and practicing law should know about and use, but that these were fields that were themselves part of law. They were within law's boundaries rather than something just outside of law's boundaries that lawyers should know about. If we jump up ahead a little bit in history, we find Lon Fuller insisting, and I should mention as an aside, I took jurisprudence from Lon Fuller. I know that for some of you, that's like describing personal experiences with Joseph Story or John Marshall, but I took jurisprudence from Lon Fuller. Lon Fuller insisted most prominently against HLA Hart, no relation to Henry Hart, in their 1950 debates in this very institution, that law included morality, particularly Fuller's particular variety of procedural morality. But the basic idea was that law included morality, that the understanding of what law was that morality was a component, a constituent part of law itself. A little bit thereafter, Harvard Law School graduate Ronald Dworkin, arguing again against HLA Hart and others, insisted that moral, legal, and political principles were part of the law, and a part that could not be captured by a so-called, as the legal positivists put it, rule of recognition that enables us to pick out what is law and what is not. For Dworkin, moral, legal, and political principles are part of what judges do. They are part of law, and that law cannot be encapsulated by any conception of a rule of recognition. Most recently, Harvard Law School graduates Judge Richard Posner and Justice Stephen Breyer, the latter also for many years a faculty member here, have very controversially been at the forefront of the view that it is both appropriate and necessary for appellate judges to engage in their own empirical and factual and scientific research, even extending to sources not litigated below, and even extending to sources not contained in the appellate record or the briefs. This is not just a debate about legal research by appellate judges. It is a debate about what counts as law. It is a debate about law's boundaries. It is a debate about the very conception of law. All of these debates are about the central jurisprudential question of our time. Is law a limited domain of pedigreed, authoritative sources, or, as people at this institution going back as well to Duncan Kennedy and legal formality in the early 1970s have argued, is it a domain that cannot be identified, cannot be limited by any particular form of, as I said, rule of recognition? And even if the idea of a rule of recognition can indeed explain all of this expanding domain, then what is or should be the nature and content of that rule of recognition? These debates about what counts as law and what does not count as law are likely to continue. They are very likely to take place, as they have in the past, at the Harvard Law School. Thank you.
Great. So just a few questions before opening it up to Q&A. Of course, I think a common theme across these remarks is that Harvard, you've described kind of how Harvard has had obviously a huge influence on shaping the law. And I kind of want to turn to a more normative question and about whether or not this concentration of outside influence at Harvard has been a good thing, although I think I know Professor Vermeule's response. But Professor Suk Gersen, you mentioned that although you disagree with Professor Duncan Kennedy's fear of the Socratic method reproducing hierarchy, and Professor Vermeule, the very influential dialogue you talk about the administrative state, though across generations was largely contained to Harvard, albeit, of course, embarrassment of riches in one sense. And Professor Crenshaw, you speak about how these conversations about legal education reproducing racial hierarchy are not new to today. They've been around for a while. And so has a critical race project gone far enough? And if not, is Harvard to blame? And so even if we can agree that the legal traditions that came out of Harvard were good, how should we think about where they came from and who was like wielding power at the time they were developed in thinking about the traditions? So that's for anyone.
Okay, so in my paper, I suggested that there were both good things and bad things. I think that to the extent that Justice Holmes was read to say, don't think at all about justice when you're doing law, I think that's a negative influence. On the other hand, there's much that's positive about the developments, including the emphasis of the three thinkers I wrote about on the importance of legislatures. And how to think about that is something others have comments on. So I'll subside.
Let me say one very quick thing about outside influence. Let me be the skunk at a picnic for a moment. I think it is wonderful and entirely appropriate that Harvard celebrate its influence. But at least in jurisprudence, especially in an analytic version of jurisprudence, let's not forget that there are also important traditions that have not taken place here. That if we start with Jeremy Bentham and go from Jeremy Bentham to John Austin, from John Austin to Hans Kelsen, from Hans Kelsen to Joseph Raz, there is a long analytic legal positivist tradition that has largely taken place elsewhere. Whether that's a good thing or not, I will leave for people to talk about and argue about and so on. But much of Harvard's influence, as I tried to talk about, has been about this question of what counts as law and about legal reasoning and about what judges do and so on, as well as various other topics. There are other important strands of jurisprudence that are less judge-focused, of which certainly the work of Bentham, Austin, Kelsen, and so on is an example that may have taken place or had less connection with Harvard. I'll leave it for others to decide whether that's good or bad.
And I will say on the topic of legal education and this method that within a few years of Langdale introducing it really became the dominant and universal method at law schools all over the country, much to many law students' chagrin. And Harvard, is to blame for that development. But also, I think you said that I disagree with Duncan Kennedy. I don't quite disagree with Duncan Kennedy. I believe absolutely that the way it was used, and maybe even is still being used in some contexts, was in fact to do exactly as he said, which was to retrench hierarchy, to reproduce it, and also to oppress students and to suppress their individuality and autonomy and all of that. However, I have to say that as a student at Harvard Law School, the classes in which I experienced the most freedom to think and the joy of debate and conflict, the exploration of ambivalence, all of that was achieved when I was a student through certain faculty members' uses of the Socratic method. And there's a way in which we should not impart all of the ways in which it has been used to the actual inherent qualities of the method itself. It is a tool, much like law, and different things have been done with it. And I really hope that these explorations about how it's been used can develop teachers and their approaches, and as well as students' orientation toward it.
Well, I guess since my song was a little in the key of sort of C minor, to continue the kind of implicit story. So Harvard's influence, I would say, around questions about how race and law are thought about and talked about, can be expressed in the fact that the response to us created a moment of galvanizing both traditional civil rights constituencies, and I'll say more particularly the civil rights establishment, to identify the kind of conversation that we were having here as being in many ways the same kind of conversation that they were trying to suppress on the other side of the line. In other words, to talk about race and power and law in the same sentence sounds like we're talking about racism. It sounds like it is precisely the thing that we're looking to law to transcend, not to in some way embed and normalize. So for many of us in that post-civil rights generation, this moment was shocking. For us, many of us thought we were doing at the law what our predecessors were doing at the lunch counters, that we were more or less staging an intellectual sit-in at the site where race and power were normalized. But when the response from many people that we respected identified us as outliers, and the institutional response to that was to double down on that outlier status, I think that had an impact on the capacity and the way in which these conversations might have been replicated more broadly had it not been for the backlash or had not been for the retrenchment. And then I'll say, just at a higher level, one of the conditions of possibility for the development of this critical way of thinking about race and law was the fact that critical legal studies was also in the building. So we had access to both faculty members who were willing to support the independent study work, willing to support the alternative course, willing to bring young scholars into intellectual spaces and groom them to be legal scholars. Critical legal studies was largely crushed, and the crushing of critical legal studies contributed to the failure of other spaces to provide precisely that kind of onboarding for these kinds of projects. Now, that doesn't mean that people of color and women weren't coming into the profession in significant numbers around the 80s and the 90s, but that's also a product of the fact that the profession was growing. So women and people of color had a stake in that. They had more access to these jobs than before. But the terms upon which many of the second and third generation came into the legal profession were already shaped by what had happened here. The tenure denials, the way in which Harvard was presented in the news as basically being, the outlier, the place where if we really want to defend law, we have to push out this conversation. So when you ask about, has the influence been negative, I would say that the story that I try to tell about the ongoing salience and significance of critical race theory is a tale against the dominant way in which many of these conversations that were begun here and shut down in particular ways here has been replicated elsewhere. So some of this stuff is in spite of the backlash against this set of ideas.
So I think if you look at the long sweep of history of this law school, a couple of things stand out. So one is, we're a very big law school, and that means we're large in scope, but also large in the scope of ideas that take hold here and that flourish here. And one of the things that struck me in working on the essay I worked on here and in thinking about our history over the last number of years is how many times you'll find sort of the leading voices on both sides of an important debate here. So if you go back and you looked at Langdell, the great formalist, where was the beginning of the realist response to that? It was Oliver Wendell Holmes, another Harvard person, right? They're debating, they're having an argument about the nature of law. You fast forward to what Professor Vermeule was talking about, and you have a really very deep struggle over the shape and the legitimacy of the administrative state, and who are the sort of the leading voices on both sides. The leading architect of the intellectual defense of the New Deal is James Landis, whose book, The Administrative Process, remains the sort of the most influential defense of a form of government that doesn't fit neatly with a tripartite view of the separation of powers. And on the other side is Roscoe Pound, arguing that the deproceduralization of law is a threat to liberty. And so, again, it's Harvard voices on both sides. And if you move forward and you think about sort of really three movements that have been prominent here in the last 50 years. So you have the legal process movement, which was the sort of the dominant view. It was predicated on a notion that we can identify reasonableness, and which is itself premised on a notion that there's a capacity for consensus. And then also out of Harvard comes the critical legal studies movement, which is a critique in part of the legal process theory, and also modern textualism and formalism, also a critique of legal process theory. And all of these have very deep Harvard roots and are associated with this law school. And I think one of the things that we've tried to do and I think been successful in doing in many instances is to encourage the kind of disagreement that produces productive debate and that makes us better at what we do and brings us closer to understanding and clarity.
And then I think another theme across the essays, at least, and many of the remarks have been pointing to legal scholarship and identifying that as an example of Harvard's impact on the law. And Professor Schauer, your essay notes that the debate between Hart and Fuller, of course, took place in the pages of the Harvard Law Review. And Professor Manning, you know that, in fact, like one of the first skeptical accounts of legislative intent was then Judge Oliver Wendell Holmes' famous article, The Theory of Legal Interpretation. And Professor Jackson, you mentioned also his path of the law. And so I was wondering if this highly consequential nature of legal scholarship may be a focal point for thinking about the future of Harvard's impact on the law. Many students here today are on HLS journals, and bearing in mind that, of course, when you publish an article, you privilege one specific type of understanding of the law or a legal tradition, and also recognizing that, as this panel represents, these theories that we publish today kind of can have carryover for decades, if not centuries, to come. And how, if at all, should students think about or internalize the future or normative implications for selecting works on journals?
Let me say a tiny thing about that. One of the things about the debates that we've all been talking about is that they were debates. And I think that at least some of the ones that I mentioned, the major contributions have been presented as counterpoints to the views of others. Holmes responds to Langdell. H.L.A. Hart responds to John Austin. Dworkin responds to Hart. Fuller responds to Kelsen. And it may be important to recognize that a perfectly legitimate and maybe even better form of scholarship is to recognize that we build on the work of others. It is less important to say, here is my brand new theory of truth, justice, equal protection, and the American way of life, than engaging directly with someone else. All too often in the worlds in which we travel, direct engagement with the scholarship of someone else gets derided as derivative or something of that sort. That's a mistake. None of us are truly novel. None of us are truly original. And the more that we can engage with what has been done before, including on the pages of journals like the Harvard Law Review, I think the better off we are, and the better off we are in understanding our own limitations and our own modesty.
I had jotted down notes that were basically identical to what Professor Schauer just said. My experience is that claims of newness, claims of complete originality tend to be very appealing to the student-edited journals, and it is something to be very cautious about. I couldn't agree more that it is the engagement with the work of others that often yields the best understandings and advances knowledge. And it's hard for students who are, in the process of learning these bodies of law, literature, to always know enough to be able to situate work. So on the other hand, I think the Law Review has developed really good practices of asking people with more experience to provide a little bit of advice, and you have a wonderful internal vetting process. So, but I just want to associate myself with Professor Schauer's comments.
Well, going back to C minor, I guess I want to lift up a possible way in which students might hear what it has been presented as both sides of debates, and at least with respect to critical race theory, a question about whether both sides of the debates are even familiar to people. So one of the reasons why I wrote my piece as an interrogation of race liberalism is that I think many people think the two sides of the debate are between race liberals and conservatives. There is a debate, and that has been largely what has been reproduced in law reviews for the last 30 years. What has not been reproduced in law reviews is, in fact, that there is a deeper conflict between race liberalism and critical race thinking. And as far as that's concerned, I would think that perhaps students might infer that if they were interested in that debate, perhaps that is not a fully legitimate framework to engage. It is not one in which it is often mentioned that we have both sides. Most institutions do not. Most law reviews do not publish in this arena. So we could either take this moment as a moment of saying and reflecting back how we come to this, and given that Harvard is very much a site of the development of critical race theory to engage in a corrective discourse around that, which would mean publishing more, which would mean understanding that actually race liberalism is not the same. Or it could be that this is just a part of our history. We could probably identify other debates that at one point in history were significant that no longer grace the pages of the review or no longer are clear areas of study and areas of teaching that a school like Harvard or other places would do. But that is a question that I would be surprised if students didn't notice it or think that it was meaningful.
Just in the interest of conversation, I want to register maybe a partial dissent from the Schauer-Jackson view. So let me explain it, and let me come at it negatively by just saying a word about the pathologies of peer review and contrasting it with a possible virtue of the law review publication process. So standard pathologies of peer review arise when you have a group of established scholars who more or less control a field. And the most obvious risk is suppression of alternative viewpoints, but I don't actually think that's the risk that most often materializes. I think the risk that most often materializes is suppression of alternative subjects. That is, these established scholars keep making people talk about the same topic over and over and over again. And I tend to think this is maybe something that Fred disagrees with, but I tend to think that a problem with jurisprudence, Anglo-American jurisprudence, has been the sort of inability to stop talking about ever more refined versions of the positivist problem out to the 14th decimal. And this is actually an example of the phenomenon I'm talking about. In light of that, what's the virtue of the law review publication process? Is that there's a certain kind of freshness that arises when law reviews are more open to allowing scholars, especially sometimes younger scholars, to bring wholly new subjects to the table. And sometimes these are scholars who actually know something about the world that is less familiar to people engaged in the current problematic. So just to tie it to one of the examples I mentioned, Elena's article on presidential administration came from, in important part, from her experience in the Clinton administration. And its great virtue was that it brought to light a set of practices and facts about the world that had not previously been on the radar screen of many administrative lawyers. So it wasn't just another move within a conventional topic or within a pre-established topic. It was bringing to the table a whole new set of problems. And I think the law review process makes space for that in a way peer review doesn't, and that's something not to lose sight of.
I should mention, in terms, I actually agree with Adrian's example. There is a reason why in talking about the history of jurisprudence, I might have stopped Posner and Breyer apart in terms of their use of other sources, might have stopped in 1980 in what I wrote and so on. I mean, we do not need one more article on inclusive versus exclusive positivism. And the great and deep and profound insights of at least many of the figures that I mentioned and some number of others have not been matched in contemporary work, which gets more refined, too refined for its own good. So no disagreement on that.
So I think we have time for one or two questions, if anyone has any. Yes.
So thank you. This has been really, really wonderful. One kind of overriding theme of many comments has been the pedagogical influence of Harvard Law School nationwide, something that I think many of us forget when we're too ensconced in Harvard Law School. So Professor Suk Gersen's comments about the Socratic method, but also the fact that Harvard Law School itself has often been so court-centric. And it really struck me from Professor Jackson's comments that when you asked in class about what a Senate counsel should do, what the Senate should do with Holmes and said fairness can't be taken into account, when Justice Holmes was focused on the judiciary and actually said if I were a legislator in his law firm dissent, I might do something different. And so one of the things that I know you've thought about this, Professor Jackson, is there a way in which the Harvard Law School could get away from the court-centricism of its teaching and start to think about the way other institutions may approach legal questions, whether it be interpretive, enforcement of constitutional provisions, and other such things? So for anyone.
So, yeah, I'll just go first on that. Yeah, I think that is one of the disadvantages that we have inherited because the Socratic method, the case method, the two of them are so tied together, that our dominant pedagogy was originated at the same moment that this was about cases and the work product and the written product of judges, and that of course contributes greatly to this court obsession that we have, starting with what the very materials that we're studying. I think that over time we can decouple that method of questioning and of debate and of discussion from the idea that what we're doing is only studying cases, and because obviously there are many, many different kinds of materials in the world that one can have this questioning process over. And I think over time we do see that we are no longer exclusively doing the case method. We're looking at different materials. We're looking at legislative materials. We are engaging in exercises where we're not just asking students to pretend that they were judges and what would they say about it as a judge, but rather asking them to do exactly the kind of things that Vicki asked her students to do. I think that there's more of that going on now, and having, even staging things like client meetings, not just oral argument in a court, but legislative hearings or different negotiations. I think more and more teachers, even though their mainstay might be the Socratic method, that might be their go-to, they have more and more of those different approaches coming in, and I think over time we'll see a much more diverse choice of materials.
I agree with what my colleague has said in terms of the practice at the law school. I will tell you how I made a minor adjustment in how I taught subsequent federal courts classes that worked. And so what I did either right before that or at the beginning of classes, I said, now sometimes I'm going to ask you a question about what legislatures should do. And you need to know that good lawyers need to have the skill of persuading decision makers that what they're being asked to do is not only consistent with the law, but the right thing. Because decision makers like to feel that they're doing the right thing. So part of being a good, well-trained lawyer is to know how to make arguments from justice and from fairness. And once I said that in class, that problem got fixed. Another approach is I've been trying so far without much success to generate scholarly interest in the idea of more fully articulating what a good constitutional representative does. We have a very thick idea about what good judges do, although it's very contested. And I've been trying to spark interest in a similar conversation about representatives, about which I sought advice from Professor Schauer many years ago. I don't know if you remember.
I should mention in this regard, the other side of my life does a little bit of writing about free speech issues. In my teaching and writing, the most important institution for me at the moment and for my students and in my classes is the Charlottesville City Council. I live in this newly famous community of Charlottesville, Virginia. What the City Council has done and what it is doing and what it is thinking of doing is now central to how I think about all these things.
So I just sat on a university committee put together by the Bach Center about case learning, and what's happening in other parts of the university is that they're trying to move in the direction away from, which we did more than 100 years ago, away from lecturing and more toward problem-oriented and inductive ways of teaching and learning. And so I think there are a lot of different ways that you can use cases. So in a lot of other schools, they put together case studies that unfold a problem, and then you analyze the problem that's presented in the case study. And anybody who's taken the California bar will know that there's a big chunk of the California bar that's built this way. It's not pleasant. But there's a way of thinking of the cases that we study as sort of collecting a problem, identifying it, laying it out, and an opportunity to look at all aspects of the problem rather than simply trying to figure out, what's the holding in this case and what's the reasoning. And I think that's a very good way of using cases, and I hope that we'll use them more in that way. To me, one of the advantages of actual cases versus case studies is that they focus the mind on a problem that's happened, and for the same reason that judges want cases or controversies because it sharpens and focuses the mind, to me, an actual case or controversy sharpens and focuses the mind in a way that I sometimes find case studies to be more diffuse. Now, that may be a point of personal preference, and there are different ways that people like to teach and different people like to learn, and I don't think there's any one right way on this. But to me, I think that is an advantage of the case method.
Thank you. Seeing as it's 12:30, I think we'll have to end there, and I certainly could not think of a more knowledgeable group of scholars to provide us with such a rich perspective on the history of Harvard and its influence on the law. And so I think it's fitting to give this panelist a round of applause. Yeah, of course. Thank you.
I'm glad we got this.